Patent pending status. What actually is this? What exactly is this? I can see there is so much curiosity amongst the inventors. They actually want to know what exactly is this patent pending status and why should we have this kind of a status with our invention, and how can we have this kind of a status. So I just thought of creating a video on this, and I'm Dr. Prachi Chopra, founder and director Intellect Bastion, and let's just today dig more deeper into the conversation of what, why and how of patent pending status. So let's just start, and before I start, I just request you all as always to please subscribe to my channel because I create videos on topics related to intellectual property rights and most often related to patents for inventors, related to trademarks, designs, copyrights, geographical indications, any of the topics which you want. You can always write in the comment box also if you have any kind of questions unanswered on any of the topics which you want the content to be created. Actually the answers to be provided to your IPR problems. You can always subscribe to my channel and always write to me in the comment box so that I can be informed about the same. Now, starting with the number one topic, that what exactly is patent pending status. See, as a definition, patent pending status means that the application has been filed. The application has been filed. Which application? Patent application. The patent application has been filed and the procedures are going on. It just means this. It actually means that your patent application has been requested in front of Indian Patent Office through filing, and this doesn't necessarily mean that you are gonna get a grant over it. It actually doesn't mean that, but yes, it definitely means that you are trying to get a grant over it and you have invested for patent filing and patent examination just because you feel that your invention is so much convincing and worth it to get a patent grant. So it actually means that, and it continues till the point your patent application is either abandoned or granted. Granted by the Indian Patent Office or abandoned because of whatsoever reasons. So till that point, you can utilize and take whatsoever benefits you want to have, which I'm gonna discuss next, that you can use this status for any of the reasons. This is patent pending status, and it's like any other pending status for any other intellectual property rights, like in case of trademarks, in case of industrial designs, if I talk about explicitly India, because in US designs are also filed as patents, but in India this industrial design is something very different from the patents. So like in trademarks, if you have applied for a trademark, you can use the status TM, encircled TM, and this shows that you have applied for a trademark and maybe you gonna get the registration over it, and when registered you can use an encircled R. So similar is the case with the patents till the point you are trying to get a grant over the patent, because it takes so much time, 2 to 5 years almost normally. So till that point of time, this status is used, patent pending status, and once you get a grant over it, it's a patent granted. Coming to the next part of this conversation, which is why should we have this status? What is the significance of this status? Why should we opt for the status? Why should we apply for the status? And there are two major reasons, two very, very important reasons for doing this thing. And the number one is commercialization. See, we need to protect our invention before coming into the market, and it's obviously required. But then it's always a bad decision to wait for 2 to 5 years to get a patent grant, because it normally takes, in India especially, it takes 2 to 5 years to get a grant over a patent. But what should we do then? We should actually have a patent pending status. This is actually a tag which we should have, and the significance associated with it related to commercialization is it actually intuitively kind of creates a positive image in the minds of potential customers, potential investors, potential business partners. It intuitively creates a positive image about the product, that obviously if the business owner has applied for a patent protection over this technology, it must be a kind of it actually he is actually uh, able to believe that the technology is obviously kind of a cutting edge technology, and that's why that person is putting so much investments to file and examine the patent application, and hence so much positive about getting a grant of the patent application for that so corresponding invention. So it creates such a kind of an image in the minds of all those people who you may try to convince as a customer, or who you may try to confront or kind of convince as well as a business partner, as a potential investor. So it actually enhances the convergence rate. It enhances the chances of getting your product sold, getting your product getting yourself collaborated with investors and partners for growing your business, because your product is being applied to get a protection through a patent, and hence it is having a patent pending status. So this is one of the major reasons. The next reason is to stave off competitors. See, the competitors always have an eagle eye in the market, that whatever other parties trying to kind of sell in the market, what exactly is the market scenario. And the big brands may always copy your work, copy your invention, and then sell it at a cheaper price. And what happens to you? Your business is finished. It's nothing left in your hands. And so the best way is to protect it first, so that you are not exploited by other businesses, because you have done so much R&D, and you have done so much effort to come up with such a big cutting edge technology, and hence you should protect it first. You should stave off all the competitors. You should inform them that beware, we have a patent pending status. That means we have grabbed the priority date, we have grabbed the filing date. It's on file with the Indian Patent Office, and hence please don't try to copy it, otherwise you'll be forced into the courts. One of the points I must clarify, and it's worth mentioning here, is that this status, for the time being till the patent is granted, helps you only in informing the competitors or copycats in the market. What best you can do is, on each of your packaging materials, ad campaigns, outlets, and marketing materials, you should write a status that it's a patent pending or patent applied for. It's a kind of a notification to all the parties who may be trying to copy your product or misuse it for their own business benefits. It's kind of a notification to them. And if in case you see someone is copying your product, although you cannot sue that person, you cannot bring that person into the courts for infringement reliefs at that point of time, but yes, when your patent is granted, you are able to take even the damages from the date on which you have notified that person. You can take backdated royalties from that person by showing proper evidences, using those tags and notifications on each and every product which that person may have, that party may have, that it was already notified from that backdated time, and hence royalties should be charged from that point of time. Injunctive reliefs should be extracted from that point of time. So this is the significance of having a patent pending status, and thus providing a patent pending notification on each and every of your marketing product or service. Isn't that great? It's actually great. Coming to the last and actually required to be discussed part of this conversation is how can we have a patent pending status? What's the actual procedure to have a patent pending status? It actually means you have to file a patent and grab this status, and it can be done using two types of patent applications which can be filed in front of patent office using your attorney or by yourself, and that is provisional patent application, either provisional patent application or complete patent application. And please check one of my videos on which I have discussed what exactly is the difference between these two, provisional patent application as well as the complete patent application. And a point to be noted here is if you go for provisional patent application, then you must know about the fact that you have to file the complete patent application within 12 months of filing the provisional patent application, and that complete application should be within the scope of whatever has been disclosed in the provisional patent application. The scope should remain the same and it should be done within 12 months. This is the most important compulsory thing, deadline, which you should be aware of. And to know how the procedures go on, you can always watch my video, which is provisional patent application versus complete patent application. I think I have informed you the what, why and how of patent pending status. Please subscribe to my channel if you are an inventor and you are likely to have such kind of questions in future as well. You are always curious to know more about intellectual property rights and how to get protection on your invention. And if still there is something which is unanswered from my side or I may have skipped it, then please do write in the comment box and I'll come up with a new video or answer to your question as early as possible. Thank you so much.